So let's get right to it. Joining me on the Go Local Live line right now is Carly Iafredi. She is super lawyer, if you will. She has this week slayed dragons heretofore thought, well, unslayable. She was involved as a volunteer attorney in a landmark legislation here at the Superior Court level in Rhode Island, protecting employees from discrimination against the use of medical cannabis. Carly, my heartfelt congratulations, and it's just a superb job. And welcome, by the way, to the coalition for the first time.
Thank you so much. I appreciate it.
Now, let's give a little snapshot, first of all. You've got your own private legal practice. And tell us just a little bit about that.
So I specialize in employment and labor law. Primarily, I represent public sector unions. This particular case, Steve Brown had asked me to handle on behalf of the ACLU because I also practice employment discrimination. So it is, I think, the first of its kind, or one of the first of its kind in Rhode Island, because if there are any other pending challenges to the medical marijuana law, I'm not aware of them in terms of the employment aspect of them. I think this is the first decision that has been rendered as to the enforceability of the statute. So it's a pretty big deal.
No, absolutely. On multiple levels. On its first, and I won't use the word superficial, but on really its first level, it affords a degree of dignity and peace to a whole body of individuals who are really challenged by infirmities, who I believe, having met many of these folks, are warriors in life, but at certain points in time, their body has failed them. It's a challenge to be employed. For many of these people, it's pain management. For many of these people, it's severe illnesses like epilepsy. And so you've got this crazy disconnect at the federal and state level where, federally, cannabis is still a scheduled drug. On the state level, we've got, I believe, one of the more, despite Gina Raimondo's efforts, those are my words, not Carly's, but despite Gina Raimondo's best efforts, we have one of the more successful medical cannabis programs in the nation. Where it's always been a challenge is, of course, in drug testing. Folks who are using prescription painkillers are allowed to be employed. Yet because of this disconnect in federal and state and local law, folks who use cannabis, until Carly's divine intervention, if you will, found themselves in the position of doing this dance, this terrible, terrible dance. And so just the peace of mind and the dignity that you've afforded these folks, Carly, is a story in and of itself. Now, you acted as an attorney on behalf of the American Civil Liberties Union. Folks, if you're new to the coalition, understand one thing. We are talk radio, we are talk media, but we embrace the American Civil Liberties Union. I believe that the folks, particularly the volunteer attorneys who litigate on their behalf, are true American patriots. There are times when across the political spectrum, they may annoy you, they may frustrate you, but guess what? That means they're doing their job. Stephen Brown has graced this program on a number of occasions, and most recently when we talked about the refugee ban. So, as we like to say on the coalition, tough darts farmer, the ACLU is with us and we celebrate their existence. But tell us about your relationship with the ACLU and how you work with them to litigate cases like this.
Well, I think like any volunteer attorney that works for the ACLU, we don't necessarily always believe in all of the positions of the ACLU, and I certainly don't. Mm-hmm. But you have to believe in the mission. You have to believe in the fact that it's important for the ACLU to exist in order to sort of police, the Constitution and make sure that even if certain positions may not be politically popular, that we still have an agency that's willing to, pursue on behalf of people who may not, be in a position to pursue our interests. I don't necessarily have any previous knowledge of anything really to do with medical marijuana or any interest in that particular area. It's a very simple concept, which is people should not be discriminated against based upon their use if that's what the statute says. And so it does say that, and it's very similar to enforcing the disability discrimination statutes or race discrimination statutes or anything like that. I think you hit the nail on the head where you said something like, for people who are sick and need to use medical marijuana, I think society in general, we should be in favor of supporting their continued, productivity in the workplace. It doesn't make a lot of sense to say we should have these people who, can't work because they're concerned about being disqualified, based on a drug test. And there are lots of employers who use drug tests and they still can under state law. It's just that if you have someone who tests positive and also has a card, what we're saying is that's essentially an exception to, your workplace policy, which might otherwise, mean that you weren't going to hire that person. So that's all it is. It's basically the General Assembly saying, hey, guess what? These people are entitled to an additional form of protection that they would not ordinarily have had if they didn't pass the law. Now, the other thing your folks should know is, this is sort of not the end. It's obviously a very big decision, and it's a big statement, and it's a very well-written decision. But we do have a final appeal process to the Supreme Court, and I expect that the company will take that appeal, and that the Rhode Island Supreme Court will have, the last word on it. There's a lot of complicated legal issues for them to resolve, and I think it's an issue of first impression, and they'll do the same thing that Judge Leach did, which is render a very thorough opinion, which could go the other way. We don't know.
Right. Now, you touched on a very important point. I am not an expert. I literally try to play one on the radio. If you could, and what was remarkable in the brief conversation we had in the run-up to the show was how accessible you made the issue. Talk about, if you will, the legal reasoning underneath, or the approach you took that was successful. I know this was this represented a challenge.
Yeah, it definitely was, and it was a challenge not because of really anything to do with the substance, meaning the protection that existed for people who are card holders, but it was a challenge because there was no express private right of action in the statute. So normally when you have a law like this, like a Fair Employment Practices Act or something, it will say, if someone violates this law, here's your remedy. You can go file a lawsuit in Superior Court. You can ask for damages, whatever. When the General Assembly enacted this particular statute, they didn't put the remedy in the statute. And so that was really what the fight was about, was whether there should or should not be an implied right of action in the statute. And the judge decided to follow mostly federal law on that point, and to imply a right where there's clearly an intention by the General Assembly to provide a benefit to a class of people who, need it. So that was essentially the fight, and we're very pleased, obviously, that he, decided it the way he did, and we think it's a huge victory for the, patient community, and we'll see where it goes from here, but I know that you would love for me to continue to talk, but if I continue to talk, I'm probably going to get divorced, as I can see in the window where dinner is served. So
that's usually where I have to sit. Carly, again, we're going to have you on the show in studio in the very near future to discuss some employment law in these situations. Again, congratulations. Our coalition hats are off to you. Folks, we'll provide some information going forward if you have employment issues and you are looking for, in fact, a super lawyer. She is the person to call. Carly, congratulations. Enjoy dinner, and apologize to your husband for me.
Thank you. Thank you so much. Take care.
Take care now. Why is this important? In the long history of the coalition, I'm not being facetious, but the 3 or 4 years that we've been on the air, we've been graced by the appearance of a number of the constituents, if you will, of the medical cannabis community. They have impressed me with their bravery, with their ferocity, with their, as I always use the term, warrior-like attitude towards life. I've had Peter Benson on the show, who has overcome incredible physical challenges to become very successful in the investment community in terms of IT operations. And I know amongst certain circles, it's so easy to dismiss this program as frivolous. I'll use that term. Not a term I like. But so many people can be dismissive of this program because, fortunately for them, they haven't had this type of illness, these type of physical challenges invade their life at some level. What's impressed me so many times, as is the case of so many issues, whether it be marriage equality, whether it be legal cannabis for patients, any issue like this. What always seems to humanize the issue for folks is when in fact it becomes part of their life. All of a sudden it's not someone going out and getting stoned with some weak excuse for a card, when it's their Uncle Jerry who's all of a sudden developed a severe form of cancer, or God forbid, they have a young person in their life who has epilepsy, and for whom cannabis on a medical level, whether it be the tinctures or delivered in an edible form, have proven to be highly effective in repressing seizures. Just like so many issues, when it's personal, all of a sudden things change, don't they? We look at things in a different light when it's someone we love, someone we know, someone we respect, and the jokes go away. As we like to say things here at the Coalition, we always take it personally. So my hat's off to the ACLU. In our WPRO incarnation, we've had them on several times. We are going to make them an active part of this program going forward. So more